All rise. The court is now in session. The Honorable Witet presiding.
Good morning. Please be seated. Good morning. Of course. Ms. Merrifield.
Morning, Your Honor.
Good morning, ma'am.
Brady Merrifield on behalf of Alexander Wardruff. This is 25 CF 2122. Mr. Wardruff is present. And Judge, this is based on my motion for partial indigency that was filed on February 4th. Did the court have an opportunity to review that?
Yes.
Thank you, Judge. So just to give a little backstory, Mr. Wardruff, I was hired by his grandmother at a reduced rate. He completed an original indigency application on November the 20th of 25. In that application, we also noted that he listed a yearly income. That was incorrect. It would have exceeded the scope for indigency, but it was also incorrect because he was terminated from employment. He had no income whatsoever. His bond was greatly reduced. As the court can see, it was $1,000 cash or professional each, so grandmother did post $100 for each charge. We filed an amended indigency application on January the 5th of 2026, and the clerk noted that that was denied because there needed to be an affidavit for attorney's fees. I did attach that, Mrs. Wardruff's affidavit for the attorney's fees. She's not with us today. She is elderly on a fixed income, but her health does not allow her to travel. So what I am requesting is for the court to review this for partial indigency. Once I took the case and after speaking with Mr. Wardruff, it became apparent that I need an expert to assist. I have some questions of competency and some other issues. So I am requesting partial indigency so that I can contract with Dr. McDonald to help me answer some of those pending questions.
Does the state wish to be heard at all on this question?
No, Your Honor, the state would defer to the court.
All right.
And Judge, I can put Mr. Wardruff, I can take some testimony from him so that the court can learn about the assets or lack thereof that he has.
All right. Raise your right hand, please, sir. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do.
All right. Ms. Merrifield.
Will you please state your name?
Alexander Thomas Wardruff,
And Mr. Wardruff, who do you live with?
my grandmother.
And who provides your basic care, like food and clothing?
My grandmother.
And are you employed right now?
No, no.
Okay. And you had a job, was your job terminated?
Yes, ma'am.
Do you own a car that you have paid for?
No, ma'am.
Do you have a cell phone that you pay for?
I did, it got taken away from me.
Okay.
So it wasn't my name.
Do you have any income whatsoever from any source other than your grandmother?
No.
That's all the questions I have for the judge.
The state wish to inquire.
No, Your Honor.
So to be clear, at the time the original affidavit was completed, the defendant listed his income from his prior employment,
That's correct, Judge.
and that employment was terminated upon his arrest for these charges.
Correct, Judge. The arrest was on October the 24th. When he completed that application, it was on November the 20th. He had been terminated for a month at that point with no income. And as the court can see in the motion, I did attach, like I said, the affidavit of fees between myself and the grandmother, and the court can see that that was performed at a reduced rate based on the circumstances.
All right, the court will make the determination the defendant is indigent for the purpose of costs under the circumstances presented.
Thank you, Judge, and I will forward a proposed order to the court.
Right, and just be sure it has the appropriate language for JAC so we don't get in that loop, okay?
Understood, Judge. That's all I have this morning.
All right, thank you
Thank
very
you.
much. Ms. Reed.
Hi, good morning, Your Honor.
Good morning, Ms. Reed.
I have, well, I am covering for Mr. Gates, who has one case on the court's docket. That's Ms. Donna Lambert, and that's going to be in 22 CF 2704. And Your Honor, before we get started, something was disclosed to me right before court. May the state and I approach?
Granted.
Your Honor, we are here, Mr. Gates has previously filed a petition to expunge Ms. Lambert's record pursuant to the rule, Florida Criminal Rule Procedure 3.692. That petition was filed January 13th of this year, 2026. I do have a copy of the electronically certified dismissal if the court would like a copy.
No, ma'am, not
No? Okay.
necessary. Does the state intend to reverse or demur the petition?
No, Your Honor, the state does not.
Okay.
All
I
right.
have a proposed order.
Oh, very good, thank you.
May I have a motion?
Granted.
Thank
All right, thank you very much.
Okay.
Anything else, Ms. Reed?
you. No, that is all, Your Honor. May I be excused?
Yes, ma'am.
Okay,
Good day, thank you.
Have a wonderful day.
She's going to prison. Yeah, but she's going to prison. I'm just kidding. No, I trust him.
Oh, sure, sure, that's fine.
Thank you for accommodating me, Judge.
You're welcome, sir.
Jay Patel on behalf of Mario Trujillo, 25 CF 2397. We're back before the court on the continuation of our motion to set bond. I've had the opportunity to, my office spoke with Mr. Trujillo and his family. Essentially, the main concern was about the treatment providers. All of his treatment that he has done before his arrest was at Bridgeway. So, so I have a proposed order, if I can approach.
Granted. State had the opportunity to review the order.
Yes, sir.
State have any issues with the order?
No, sir.
If there's further specificity the court would like to discuss with counsel, happy to approach on that.
No, sir. All right, so ordered.
Thank you, Judge. Next, Judge, there's an add-on that I had, J.C. Wright, 25 CF 2185. This is a stipulated motion, rather it's a motion to reinstate bond, but it's a stipulated order. If I can approach on that.
Granted. State agree?
We do, Your Honor.
And on those, you could just send them through the queue if there's a stipulation. I don't have any need to have a hearing.
There was an issue with timing of everything, and I wanted to just add it onto this docket to make sure he gets out of jail.
All right. Bond is reinstated.
Thank you, Judge. May I be excused?
Yes, sir. Thank you. Actually, hold on. I think I show another case with you, Mr. Patel. Hold on. No, I apologize. That's it.
Perfect. Thank you.
Good day.
Trevor Brown, Mr. Little. Good morning, Judge Russell for the state.
Good morning.
Good morning, Judge Michael Griffin. I represent Mr. Brown, who's present in the courtroom. I'm going to file one.
Yes, sir.
Just to get his status. Judge, may we approach for a moment?
Granted.
Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
Hi, I'm I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
So we were on today, though, we were on today for a motion hearing, correct?
We were, Judge.
We were.
I'll get with Mr. Griffith.
We'll get that rescheduled, Judge.
We'll get it rescheduled, Judge.
Okay. All right. So just simply for the Madam Clerk, we're simply pulling it off the docket and it'll be reset after the parties have an opportunity to talk. Is that what we're saying?
That is fine.
Okay. So my notes are just say we're pulling off the docket, you'll meet and confer and reset if needed.
Yes, sir. And as I understand it, we're scheduled for March 9th at, I guess, 9 a.m. and potentially,
Well,
juries.
technically, since your client is in detention, March 9th is pretrial, but since he's in detention, he'll actually be seen on March the 11th.
March the 11th?
Right, but everything's set on the 9th just for administrative reasons, trying to keep the docket clean.
Will I have to be here the 9th, or will I be?
No,
here?
just the 11th.
The 11th, okay.
Yes, sir. I mean, assuming you don't have anybody who's out of detention.
Yes, sir.
For the 9th. Okay. All right, and we'll address it then, just feedback with Mr. Little on the other issues and also on your timing.
Thank you, Your Honor.
All right, thank you. Now,
I'm
good
happy
day.
excused. I
Yes,
think
sir.
that's all my business before the court today.
Yes, sir. Good day.
Judge Stone, that's all I have for today.
Yes, sir. Thank you. Good day. Ms. Shakley.
Thank you. Your Honor, the first I have is Michael Riley. Mr. Riley is before the court in 25 CF 127, 25 CF 189, and 25 CF 217. Just to briefly refresh the court's memory, Mr. Riley was continued to today so that he could make a little more progress in the ECLC program, and then he's going to be waiving credit, pleading to 1129 as a downward departure, based on a legitimate uncoerced plea bargain for the purposes of staying in the county jail to complete the ECLC program. If I may just pause for a moment, Mr. Riley does have a copy of this plea agreement, however, I need to have him sign it. As to all counts in all cases, Mr. Riley is going to admit the VOPs. The agreement is that he'll be adjudicated guilty of that violation, that he will be revoked and terminated from supervision. He'll be sentenced to 11 months and 29 days in the Okaloosa County Jail. He is waiving all of his prior jail credit to effectuate this sentence. There is a $150 cost of defense in the 127 case number, and another $100 cost of defense in 189, and another one in 217. He will need to pay a total of $300 cost of prosecution. All counts and cases will remain running concurrently to one another. We would ask that the court either provide him with 12 months after his release to comply with the payments, or give him just a full 24 months to comply with those payments. I have completed the score sheet and everyone has signed the plea agreement. May I approach?
Granted. Raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir, I do.
All right, and you can put your hand down. Now, you heard what Mr. Jaquith said, and you signed the written plea form.
Yes, sir.
All right, and how old are you?
26.
And how much school do you have?
Last grade I attended was 8th.
Mhm. But you're in the ECLC, and if my memory is correct, you've completed a whole bunch of those classes, right?
Yes, sir.
You able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And is what Ms. Jacobs said, what you read in the plea form?
Yes, sir.
Now, this disposes of your violation of probation, right?
Yes, sir.
All right, and by doing this, do you understand you're admitting the violation?
Yes, sir.
And you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
And you will be adjudicated guilty if you're not previously, and you're going to be sentenced to, and this is all counts concurrent, is that right?
Yes, sir. Essentially, he'll be sentenced to 1129 in the county jail concurrent amongst all the charges. The counts that I've laid out in there are just for the purposes of the fact that the misdemeanor counts were already time served.
They're very timed out. They were already time served?
They were, Your Honor.
Okay, so they're not actually in play in this plea agreement.
That's correct, Your Honor, but I just wanted to make sure that he didn't get held up at the jail because those counts weren't addressed. So I was just trying to make sure we addressed everything clearly, as clearly as possible.
So all of the misdemeanors have previously been sentenced, and that sentence has been served, so this is a sentence only on the felony counts.
That's correct, Your Honor.
Okay. So Madam Clerk, please make a note of that. So you'll be sentenced to 11 months, 29 days in the county jail, and you're waiving your credit that you may have for any time. Do you
Yes, sir.
understand that?
Yes, sir.
And so that's important because the law gives you the right to any credit, and this is an exception, an exceptional thing for you to waive that credit. You understand?
Yes, sir.
Okay. And you believe that this is a good thing to do because of the deal that you're getting and all the other things considered to
Yes.
waive your credit?
Yes, sir.
All right. And we agree that the 1129 starts from today?
That's correct, Your Honor.
Okay. And so you understand that all the credit you have is gone, and your 1129 starts today.
Yes, sir.
Okay. Now, Ms. Jacob answered all your questions about the plea and how it affects you.
Yes, sir.
Satisfied with what she's done for you.
Yes, sir.
I'll find the plea to be freely and voluntarily entered into. I'll accept the plea, and I'll give you 12 months after you're released to comply with your financial conditions. Now, as long as you're making payments, if you need more time, you can ask me for more time, and I'll give you that time. Okay?
Yes, sir.
All right. The goal here is to be certain that you get your payments made to set you up for success, so that doesn't hinder you on anything else. So if you're making those payments, I'll help you out.
Yes, sir.
Okay? Find the plea to be freely and voluntarily entered into and accepted.
Thank you, Your Honor. The next I have is Mr. Witek, Your Honor, Matthew Witek, in 24 CF 2710. Your Honor, we have worked a resolution for Mr. Witek in which Mr. Witek is going to go into the Bridgeway 90-day treatment program in hopes that that will assist him in getting into the Bridgeway apartments to maintain his mental health treatment. However, there's kind of a little bit of a hiccup because he's got a Walton County warrant pending for VOP because he had a concurrent Walton County case that he was also on probation for. Because that warrant hasn't been served, there's not really any way for us to effectuate getting him to Bridgeway. So what I discussed with Mr. Witek, and he's fine with doing it this way, if the court will allow, is we're going to continue this case 2 months. I'll do a motion in order to transport as soon as I get back to the office to allow him to go to Walton County and resolve Walton County, so that he can, we've already spoken to the state attorney over there, who is going to be fine with reinstatement with some additional conditions. And so we'll get him reinstated in Walton County and then bring him back. My intention is to get him evaluated by Ms. Myers today or tomorrow before he's transported for the 90-day program, so that as soon as he gets back to Okaloosa County, I will go ahead and get him over to Bridgeway, and then we'll bring him back to resolve his case for whatever the next court date is. So that is our plan, if the court will allow us to do a little bit of legal gymnastics to get that effectuated. So I would just ask to give a 2-month continuance on this to whatever the second date in April is. Obviously, we'll move him back up if he gets back sooner.
Does the state agree with this approach?
Yes, sir.
April 23, Madam Clerk?
That's correct.
Thank you, Your Honor. And
4/23.
I will get that motion in order filed this morning.
All right, thank you very much.
Yeah.
Thank you, Mr. Witek.
And Your Honor, I believe that's all I have this morning, if I may be excused.
Madam Clerk?
That's correct.
Okay. All
Thank
right,
you, Your Honor.
Thank you. Mr. Powell. Good morning, Mr. Powell.
This is Vicky Robinson, Judge. It's case number 217-2084. We're here on a motion to convert the prison sentence to probation.
Silence your cellular devices.
All right.
On February 18th, 2019, the court sentenced Mrs. Robinson to 10 years probation, followed by 10 years prison. During this probation, she's paid all her fines and complied with all conditions. She's been gainfully employed at Sam's Wholesale for 10 years. She's fully complied with the probation officer. There's been no violations or technical violations. And she's paid all her money. The victims in this case, Mike and Kathy Wright, wholeheartedly agree with the motion, and they asked the court to approve it. She's paid all her restitution and hadn't missed a day or hasn't been late a day. Her payments to Mr. and Ms. Wright. Probation officer has no objection. This is, in fact, the victim sent a letter to the court, and I filed it with the court. This falls square on Florida statutes 948.12, which this is a split sentence. Statute deals completely with that. Split sentences, probation followed by prison, and the court may impose a split sentence whereby the defendant is sentenced to a term of probation followed by a period of incarceration. And with respect to the felon, if the offender meets, this is on that statute, parenthesis 2, parenthesis A. If the offender meets with the terms and conditions of probation or community control, any terms of incarceration may be modified by the court to eliminate the terms of probation. And she's been a model citizen, on probation. She's complied with everything. She works continuously. And the main point is the victims definitely requested and urge the court to accept it.
State.
Your Honor, would ask if the counsel could approach the bench briefly.
Granted.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items, and we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Wright Realty. Helping qualified heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire. Take one. Have you been injured in an accident and need righteous representation? Call us, because we fight fire. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Coy Browning. Personal injury is no joke. Just ask him.
Injured? Take a breath. Call Coy.
We're open Saturday 10 to 4, Sunday 10 to 3, and it's both our Crestview, Fort Walton Beach, and Eglin Air Force Base locations. So you have things to do, go and do it. Just know the UPS store is going to be here. Again, Sundays 10 until 3 p.m.
State, will you approach, please? And who, well, let's finish with, not you, Mr. Powell, I'm sorry. I'm trying to multitask and I'm not good at it. So, you want a minute to explain to your client what's going on, or we just?
I can tell her, Judge.
Okay. Okay, and you'll reset it if necessary, otherwise I'll expect an order.
All right, thank you, Judge.
Thank you, good day.
to see you, Judge.
All right, now, who's the defendant? Christopher Robinson. Who's representing Robinson?
I'm the only public defender here, so I can.
All right, well, please approach with the state.
Yes, Your
Christopher, correct?
Christopher Robinson, yes.
Oh.
Right. All right, yes, sir. All right.
Good morning, Judge. If I may call a couple people in the gallery this morning. First up, Mr. Corey Helnets, 25 CF 575. Yes, Your Honor. This morning, this will be an admission to the violation of probation. To announce the terms, he was previously adjudicated, so adjudication of guilt. We're going to reinstate all the original costs, all the original conditions. We're going to modify to add a substance abuse evaluation within 30 days and any recommended treatment to be started within 60 days. We have $100 cost prosecution, $100 defense costs, and the $50 PD application fee. If I may approach with a signed plea form and score sheet.
Granted. State?
That's correct,
All right, raise your right hand for me, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
I do, Your Honor.
All right, and this is a violation of probation plea agreement, correct?
Correct.
And did you read and sign the agreement?
I did, Your Honor.
All right, and according to this agreement, you're admitting the violation.
I am, Your
And
Honor.
that tells me, yes, I violated the way the affidavit report filed by my officer says I did.
Yes, Your Honor.
And by doing this, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, Your Honor. I understand.
And in this case, you were previously adjudicated, and you'll be reinstated to all your conditions with the addition of the evaluation and within 30 days. And then if treatment is recommended, you have to start that within 60 days and the additional fees and costs. Is that what you understand?
Yes, Your Honor.
Mr. Koch answered all your questions about the plea and how it affects you.
He has, Your Honor.
Are you satisfied with what he's done for you?
Very satisfied,
The court will find the plea to be freely and voluntarily entered into and accept the plea.
Your Honor, just one additional matter. When we originally pled this out, my client does have restitution amount of $800. We originally waived the cost supervision. I'm asking if we can still maintain that waiver of the cost.
Waiver is maintained until the restitution is paid.
Excellent, Judge. Thank you.
All right, thank you.
Thank you, Your Honor.
Judge, next in the audience, he's unrepresented, but he is present, Mr. Levi Pierce, last name Pierce, 25 CF 580. He is approaching.
All right, you're here today without an attorney. Do you wish an attorney to assist you, or would you like to hear what the state has to say first?
I'd like to hear what the state has to say first.
Okay.
Your Honor, as of right now, we don't currently have an offer. I've spoken with Mr. Koch in anticipation of this. I anticipate him being appointed. I'm working with probation on this. This is a little bit of a different violation that I've seen before, so we're trying to work through it before we understand exactly what it is or why it was violated. I understand
Right, and so if you'd approach.
Hi, I'm Wanda Roberts. For the last 20 years, I've been helping the residents of Northwest Florida buy and sell their properties. My office is just 1 block south of the courthouse in historic downtown Crestview. Give us a call at 850-398-5389.
Hi, I'm Michael Gilbert, defense attorney with Warrior Law. I represent those accused in Santa Rosa, Okaloosa, and Walton County. If you or anyone you know has been accused of a crime, give us a call. We can help.
All right, so we want to reset this for next Thursday? Is that what we're saying?
Next Thursday, Your Honor, I think I'll have an answer from probation and communicate with them a little bit more clearly on the violation, and we can get a resolution with that.
Okay, we'll set it at 12:30 on Thursday. That's what, 26?
26, Your Honor.
26 February.
For clarification, Your Honor, is the PD's office appointed?
PD's office is
Excellent. So, next Thursday at 12:30.
And if you'll, Mr. Koch, if you'll get your client to fill that out and turn it back in, but I'm appointing based upon my review of that, of the record.
Excellent, thank you, Judge. Just have a seat for a minute. Next, Judge, if I may call Ms. Powers, who's present in the courtroom. She's currently unrepresented, and that's Nastasia Powers, 24 CF 2259. She's present and approaching, currently unrepresented.
All right, good morning. You're here today without a lawyer. Do you want a lawyer to help you, or you'd like to hear what the state has to say first?
I would like to.
Your Honor, I spoke to Ms. Powers briefly and Mr. Gomez. This is currently a 9-month county jail offer on the table for this violation of probation. I did speak to Ms. Powers. I represented her on the original plea. I believe she wishes to get the PD appointed, Your Honor.
That's correct, Your Honor. The offer would be education and jail with both attorney and supervision, 9 months in the open county jail.
if you'll complete the application and turn it back in, and we'll give you a new court date after you turn that in today, okay?
I'll get you that. And I have no more in the courtroom, Your Honor.
All right. All right. Then let's queue up the folks in the feed. Yes. What's he on for today?
If I'm not mistaken, Your Honor,
Corey Warren.
okay, so, Mr. Noakes.
This is the 3850, correct?
That's correct, and I think today, Mr. Noakes has filed a motion to withdraw on January 29th, 2026, which may be why he's not here, I don't know. But as of how I understood it, as of yesterday, there wasn't any order that removed Mr. Noakes, and I think we were kind of waiting to see what occurred with that motion to withdraw, from what I understand.
See if we can figure that out real quick. Yes, we have the order, but we were uncertain who we could appoint. I think that's the situation, right? Madam Clerk, who's the next on the list?
It'd be Mr. Riosty.
I think he's already been appointed and withdrawn, hasn't he? Well, let's have Mr. Barnes real quickly, and we'll tell him what's going on, and I'll explain what's happening. And I'll tell you, after the hearing, I'll have my JA get with you to see if we can just go down the list to figure out who needs to be appointed. Good morning, Mr. Barnes.
Good morning, sir.
And so Mr. Noakes has filed a motion to withdraw.
Yes, sir.
And because of the age of the case and the number of lawyers that you've had and the number of lawyers who've withdrawn and been conflicted off, we've exhausted the regular list I have of lawyers.
Yes, sir.
And so I'm going to have to have my assistant get with court administration and figure out who to appoint next, since I'm off the end of my list of appointments. Does that make sense?
Yes, sir. Yes,
And
sir.
so once we do that, then we'll be able to tell you who should be appointed for you.
Yes, sir.
Okay?
Yes, sir.
Okay?
Yes, sir.
And you'll get a copy of that order at the jail.
Okay, sir.
Okay?
All right, thank you, sir.
All right, thank you.
Judge, is there a next scheduled date?
Yeah, he's already set, isn't he? Is he set for?
No, sir, there's not
Okay,
another.
just for the safety valve, thank you, Mr. McKinney, let's set him for March the 12th as a status. That way he doesn't get dropped off, and also we don't have to worry about him being transported back, so he'll still be here to have access to the new counsel.
All right, thank you, Judge.
You're welcome now. Good day, sir.
This will be David Picowski.
What's the name?
Picowski.
used to have Koch.
Let me go grab it. Judge, may I have one moment?
Yes, sir.
One second, hold on 1 second, I just want to make sure. Thank you, Judge, I was just speaking to a client outside. Has the PD been appointed yet to Mr. Picowski, as VOP?
Stand by.
Originally had your case, but technically I get appointed to you. That's what the judge is checking right now for us.
Does he have a new case?
Negative, Your Honor, this is a violation of probation.
But I have a misdemeanor new case.
Oh,
That's
you
why.
did?
That's why I violated.
Okay, that's why we're at Rand's.
All right, Picowski. Let's see. You see that case, Madam Clerk?
I'm looking for it now.
Yeah, I get it. I got you. What I might do is I'm gonna get appointed officially, and we're getting the basis of that misdemeanor case.
Yes, sir, I do see that new misdemeanor case.
What is that, please, Madam Clerk?
26 MM 165.
165.
Yes, sir.
And looks like the PD has been appointed in that case, so I'll appoint the public defender in this case.
Excellent. Now that I'm being appointed, Your Honor, may I just have a brief moment to speak to Ms.
Back Home Bakery Cafe is 2 blocks from the courthouse on Crestview historic Main Street. We serve handmade pastries, espresso, and lunch items. And we're open Tuesday to Saturday from 7 a.m. to 4 p.m., serving lunch from 11 to 2. We hope to see you soon.
Hello, I am Bonnie from Body Be Healthy here in Crestview. We have been serving the area since 1999. We're an alternative health food store. If you're interested in bettering your health, we'd like to invite you to stop by. We're located in Court Plaza. Stop by and let us help you be healthy.
I'm Amanda Gaskin with Wright Realty. Helping qualifying heroes save money is my passion. When I help a hero buy or sell a home, they receive a check from Homes for Heroes. Check out amandasheroes.com for more information.
For more than 70 years, the sweet aroma of the Crestview Coney Islands burgers and hot dogs has permeated the downtown area. If you have not experienced the unique flavor of Crestview's Coney Islands burgers and hot dogs, then I encourage you to join us for lunch. Monday through Thursday from 10 a.m. till 3 p.m., Friday from 10 a.m. till 4 p.m., and Saturday from 10 a.m. till 2 p.m. We're located in historic downtown Crestview at 107 North Main Street. Call 850-683-1045.
Hey, I'm David at Family Vision of Crestview. We've been providing excellent optical service for Northwest Florida for over 34 years. Come in and let us take care of you.
Man, I got this. Let's roll. Fight fire with fire, take one. Have you been injured in an accident?
Your Honor, on this plea form, like I said, Mr. Picowski, we are on the violation of probation in 25 CF 2134, violation of probation in 25 CF 2401. I hand wrote that new law, the 2026 MM 165, possession of drug paraphernalia. And on all the handwriting, my client did initial by me. The terms will be to the violation, probation, we're going to admit to the violation, adjudication of guilt, 9 months in the Okaloosa County Jail with credit for all time served. There's $200 in the violation of probation, cost of prosecution. There's $200 in defense costs and $50 for the public defender application fee. Revoke and terminate probation. In the 26 MM 165, this is that new law violation, adjudication of guilt, 9 months, Okaloosa County Jail, credit for time served, $270 in court costs, $100 in defense costs, all counts and cases to run concurrent. If I may approach with the signed plea form and the score sheet.
Granted. Raise your right hand for me, please. You swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, Your Honor.
Okay, and you put your hand down. Now, you signed the written plea agreement, right?
Yes, Your Honor.
And you got two things going on in this plea agreement. You got your violation of probation and new charges, right?
Yes, Your Honor.
All right, we're taking care of them together, but they're different things, right?
Yes, Your Honor. I just have one question. So it says credit for all time served, but the new law violation was in January. Do I still get the 37 days from December, or does my time start in January?
Well, you know, that's actually a good question. You'll get credit for all your time that you've served on the individual cases. So any time you've got on the felony cases before, you'll get credit for them. But on the misdemeanor case, you'll only get credit from the day you were arrested on your misdemeanor case.
Okay, because then that puts me out that's like a fresh 9 months instead of with the VOP one, I have almost 50 days in on it.
Mm-hmm.
And the new law violation, I have like 10 days.
The state will agree to run the cases coterminous as well.
Thank you. Thank you, I appreciate that.
Concurrent and
Mr. Gomez.
coterminous, right?
Thank you. That's all I was asking. Thank you.
Why don't you endorse that and have him initial?
Thank you, Mr. Gomez.
Yeah, and we're taking the plea on the misdemeanor, the new misdemeanor case.
Yeah.
So you just initial by me. put all counts in cases to run concurrent and coterminous. And we all initial by if I may approach.
Granted.
Thank you.
Thank you, Your Honor.
You're welcome, Neil. All right, so with that, you still got two things, right? You read the plea form,
Yes, Your Honor.
and you understand that you're admitting the violation.
Yes, Your Honor.
Waiving your right to a hearing where the state would have to prove it.
Yes, Your Honor.
As to your new charge, do you understand you're pleading no contest?
Yes, Your Honor.
And that tells me you believe the state could prove your guilt, and you're not going to contest that.
Yes, Your Honor.
And do you understand by doing this, you're waiving your right to a trial by jury where the state would have to prove it?
Yes, Your Honor.
All right, and we've discussed this. You're going to be adjudicated guilty of everything. You'll have the fees and costs that were announced. The case is going to run concurrent and coterminous, and you're going to serve 9 days in the county jail, credit for time served.
Okay, yes, Your Honor.
9 months, Judge.
9 months.
9 months. Sorry. 9 months in county jail, credit for time served. How much time do you need to get all your fees and costs paid after your release?
About 90 days.
You think you can really do it in 90 days? Because you got on your...
Can I have a year then?
Yeah, you can have a
Okay.
year. My
Thank
goal
you.
here is to be sure you get it paid, because if you don't, then the clerk's going to report it unpaid, they're going to take action against you, and it may have adverse consequences outside of this. So as long as you're making payments, if you need more time, I'll give you more time, but if you're not making payments, don't ask for more time, right?
Okay.
You understand what I'm saying?
Yes, Your Honor.
The goal here is to set you up for success, and if you're not helping yourself, I'm not going to help you either.
Okay.
Okay?
All right. Thank you, Your Honor.
All right. All your questions about the plea now been answered?
Yes, Your Honor.
Court will find the plea to be freely and voluntarily entered into and accept the plea.
Thank you, Judge.
Thank you, Mr. Judge. Thank you, Mr. Gomez. Thank you, Mr.
All right. Levi Pierce. All right. I've reviewed your application. Now, you said that that's biweekly, so there's some months where you get 3 paychecks.
Yes?
Okay, well, just confirming, because it's a confusing government form, right?
Yes.
So there's some months you get 3 paychecks.
When the time falls, when I, yes, sir.
Yeah, all right, and that's what you take home?
Yes, sir.
So that's, and it's not a trap or anything, I just want to be sure we're clear. And that's how much you take home after your taxes and everything?
I've only just got the job recently, and I'm still trying to gain hours through the company.
Okay, so how long you been working there?
Beginning of the year.
Okay. Does this represent average of what you've gotten each paycheck since then?
Maybe $800. I wasn't sure the form I was asking.
Right, because it says I have take-home income of blank and then a place to check the boxes, and you checked bi-weekly, right? Which means every 2 weeks, means some months you will get 3 paychecks, and then you put the amount, I'm not going to announce it on the record, so that would be the take-home after your taxes and any other lawful deductions. So that's the key issue for Madam Clerk over here to calculate whether you qualify or not. So that's the real question. I can turn this noise on, and Mr. Koch can help you with a form real briefly. My goal here is I'd rather do it once than do it over. So if you've got questions, that's the reason I like to review it. It is a goofy government form. If I hadn't been doing this all these years, I wouldn't know how to fill the darn thing out. So this is not trying to pick at you or anything. It's just trying to be sure it's right. So we only do it once, that's all.
Thank you.
correct bi-weekly
Okay.
amount, Judge.
Okay, very good. And I think that you will qualify. The clerk will review this. If they say you don't qualify, they'll tell you why. If you think the clerk is wrong, get what you have that shows the clerk is wrong, give it to your lawyer and bring it to court with you next time, okay?
Yes, sir, thank you.
Very good. I gave you my card. Next Thursday, 12:30.
So it's a denial and set next Thursday at 12:30.
Yes, Judge.
We expect a disposition.
I believe so. Speaking with Mr. Gomez.
Yes, Your Honor, the state does expect a disposition on Thursday.
I need to go these on.
Okay,
Excellent.
very good. See you then. Stay in touch with Mr. Koch.
Yes, sir,
All
thank
right.
you, sir.
And now we have Ms. Powers.
You're welcome.
And it appears you do qualify, and I'll appoint the public defender to represent you in this case. Now, the clerk will review this, and if the clerk says you don't qualify, they'll tell you why. And if you think they're wrong, get what you have shows they're wrong, give it to your lawyer, and bring it to court with you next time.
Excellent. And Your Honor, I'll be entering denial this morning, and can we get that March date at 9 o'clock?
And I've got March 12 or March 19.
Do you think you get everything done by March 12th, or do you need that extra time? March 12th? Judge, if we can get the March 12th at 9 o'clock.
And that's with a denial, correct?
Yes, Your Honor.
All right, 3/12 it is. Stay in touch with Mr. Koch, and we'll see you back on 3/12, okay?
Morgan, what's that?
This is Morgan Whitsett before the court. She was originally set on court last week. I believe the court appointed me last week to this case. I did not see that in the minutes. She's here for a violation of probation in 24 CF 1277.
She wasn't transported last week, I believe, was the
Correct.
issue.
Correct.
And my notes show that I did appoint you.
Yes, Your Honor.
So,
If we can notate that on the minutes, just to make sure that my numbers are right.
all right.
And then if you give me just one moment, I believe we'll have a plea agreement.
File. Damn thing ain't working. Whoa! Not cool, bro.
I'm attorney Kool-Aid Browning. Personal injury.
Judge. Judge, at this time, Ms. Whitsett is going to admit to the violation of probation in 24 CF 1277. The agreement with the state is for an adjudication of guilt. Previously, there was a withhold adjudication in this case. 150 days of Okaloosa County Jail with credit for time served that will revoke and terminate her probation with a $100 BOP fee and a $150 cost of defense. Ms. Whitsett's going to ask for at least a year to make payments with the clerk before anything goes to collections. May I approach?
Granted.
I have reviewed, I believe the court is going to be with Mr. Snell. Have no objection.
Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under... Okay, and you can put your hand down. You heard what Mr. McKinney said on your behalf, and you signed the written plea form.
Yes, sir.
And do you understand that by this plea arrangement that you're admitting the violation?
Yeah.
And that tells me you agree that you violated the way your officer says you did in the affidavit and report.
Yes.
And by doing this, do you understand you're waiving your right to a hearing where the state would have to prove your violation?
Yes.
And you'll be adjudicated guilty, if not previously, and you'll be sentenced, is that 150?
That is 150.
150 days in the county jail, credit for all time served. Your probation will be revoked and terminated, and you'll have the additional fees and costs. And you said a year to pay?
Yes, sir.
Okay. And if you're making payments and need some more time, then you can ask for it, and I'll provide that to you. Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
Are you satisfied with how he's represented
Yes,
you?
sir.
The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
Next is Michael Ankram.
Good morning, Your Honor. We have Mr. Michael Ankram, case number 15, CF 1024. This is going to be an admission this morning, Your Honor. You can sign and date. Your Honor, in exchange for admission of the violation, the state has agreed to 24 months Department of Corrections, which stipulated that the credit is time served in Bureau of Prisons, $100 cost prosecution, $150 public defender fee, and this would revoke and terminate his probation. I have the signed form and a score sheet if I may approach.
Granted.
And there is no objection to this score sheet.
All right, raise your right hand. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
Okay, you can put your hand down. Does the state wish to be heard? Okay. All right, you heard what Mr. Cochran said and you signed the written plea form.
Yes, sir.
And how old are you?
33.
How much school do you have?
11th grade.
All right. You able to read and understand the plea form?
Yes, sir.
And did you do that before you signed it?
Yes, sir.
And is what you read in the plea form what Mr. Cochran just announced to me?
Yes, sir.
All right, do you understand that you're pleading, that you're admitting the violation in this case?
Yes, sir.
And by doing that, you're waiving your right to a hearing where the state would have to prove your violation.
Yes, sir.
And my understanding is you were previously adjudicated guilty, and that you're agreeing to a 24-month Department of Corrections sentence in this case, which is a guideline sentence.
Yes, sir.
Under the circumstances. But the state and and your lawyer have agreed that you have already served that time in another institution.
Yes, sir.
All right, and therefore this constitutes a time-served sentence, but it is a guideline sentence.
That is correct.
Now, Mr. Cochran answered all your questions about the plea and how it affects you.
Yes, sir.
You're satisfied with what he's done for you.
Yes, sir.
The court will find the plea to be freely and voluntarily entered into and accept the plea. Thank you.
We have Jerry Bowman. Bowman?
Your Honor, we have Mr. Jerry Bowman. 1 second. Case number 21 CF 0555. Your Honor, we're gonna ask to continue this to the next court date. I'm not sure what the state, what that date would be.
With or without subs?
Without.
I've discussed that, Your Honor, I agree to that.
Okay, so March the 12th. No subs.
All right.
And we've already done, this would be this arraignment, so it's with a denial?
Yes, Your Honor, there would be a denial.
Mr. Cochran, based on our conversation, do you think we should push it a little bit further than?
Well, I think we should be fine by then, because my stuff was started last month, so it should.
Oh, okay, sorry, that's
Yeah.
fine.
Okay. All right, very
Okay,
good.
so March 12th.
312, no subs.
Next we have Willie Height.
Yes, Your Honor, now we have Mr. Willie Lee Height, case number 25 CF 1512. May I have one moment, Your Honor. Your Honor, I'm asked to set this for 312. I'm talking to the state. We're trying to work out an agreement.
All right, that's with a denial.
Yes, Your Honor, it would be a denial.
$312, no subs.
Thank you, Your Honor.
Thank you.
Judge, may I call one on the audience?
Granted.
Jaleesa Thornton.
Thornton?
Thornton. This case is 25 CF 8. It was set on the docket today as a status for pay and dismiss.
Correct.
As chair of business, I believe the state would have an announcement.
Yes, Mr. McKinney, Your Honor, provided me a copy of the receipt that the payment was made this morning. There was a zero balance, so at this time, the state would dismiss 2025 CF 8.
Case is dismissed. Thank you.
Thank you, Judge.
Next we have Christopher Carpenter.
Judge, this is Christopher Carpenter before the court in 16 CF 1849. And Judge, we had previously entered a denial in this case and set it for today. I have been in discussions with Ms. Leone, who's taken over this case with CAC. I'm going to request a continuance until the March 12th date without subpoenas so that we can continue to collaborate. There are a number of moving pieces in this violation of probation that we don't normally deal with, including a hearing in Ohio that I'm trying to get my hands on that's referenced in the violation report, potential body camera footage out of Ohio, and going back to the original sentence to see how it was structured. So those are all things that I'm going to discuss with Ms. Leone in more detail before we come back on our next call it a status date.
Yes, Your Honor, I agree with that.
Okay. All right. So 312, no subs.
Correct.
Next we have Dejan Kimbrough.
Judge, a similar situation with Mr. Kimbrough. I've been in discussions with Ms. Leone, who's taken over this case. I'm going to request a continuance until March 12th so that I can review this further to determine where we're at as far as the offer. So I'd like the opportunity to discuss the case further with her before we get to that position.
State,
No objection, Your Honor.
continued 312, no subs.
I can't speak up.
Yes. That's anything back. Yeah, I don't know, but yes. Yeah.
Tracy Rosado before the court in 23 CF 457. When we were here last, we discussed an APD order that was signed by the court. That evaluation has taken place. I'm still awaiting the results and evaluation report from that to move forward, but I'm hoping that opens some doors with APD. This case is now going to be handled by Ms. Leone with CAC. So I'm going to request that we come back on March 19th for a status for Ms. Rosado to see where we're at with APD. If I get an answer ahead of time, then I'm going to be reaching out to the court to try to get her on an earlier available court date if possible, given that the goal is for placement with APD here.
Yes. And so we'll continue to 319 with the understanding that if you get the report, then we can bring her back anytime I'm here to go ahead and take the plea and make the placement.
Yes, sir. Thank you.
Okay. All right. Very good.
Thank you.
Thank you, Judge.
Next, we have Tammy Rothbecker.
Judge, this is Tammy Rothacker before the court in 23 CF 1029. I have this case opened as Davidson Rothacker, which is why I'm handling it instead of Mr. Koch. Today's an arraignment for a violation of probation. I have discussed this case with the state, and we have not been able to reach an agreement today. We are going to enter a denial and ask for this to be set on the next available court date without subpoenas.
No objection. 312, no subs.
Correct. And Judge, if we are in a position to file a bond motion for Ms. Rothacker, then I will coordinate that. I'm making an extra record right now because I know the victim is present in the courtroom. Sometimes we set those court dates on Thursdays.
Correct.
To make sure that if we filed that bond motion and asked for it to be set on Thursday, that the victim would know that that's a possibility.
Correct. And just be sure we follow the protocols for appropriate notice for the state to be able to discharge their constitutional obligation.
Yes, Your Honor.
This will be Ebony Williams.
Did you have any questions for me? Wait. Wait a second. I talked to them, they're gonna want you to report to Fort Walton Beach, not Westview. For both.
it's not custody if it were up to me.
And we're ready, Judge. Ms. Williams is here in two case numbers, 26 CF 186 and 25 CF 1637. It is early in the process in the 26 CF case number, but I've discussed this fully with Ms. Williams. She's in a position that she wishes to accept the state's offer. The state's offer is for a plea as charged, adjudication of guilt, 3 years of state probation that is concurrent and also concurrent with Walton County, where she has a 3-year probationary sentence. Special conditions are that she is barred from the premise of these offenses, that is surf style, any surf style, and any Ulta. There is an anti-shoplifting course, and restitution shall be made in 26 CF 186 of $579.68 to surf style. I've included their address on the plea agreement. 25 CF 1637 is restitution $1,141 payable to Ulta, and I've also included their address as well. Special conditions also include maintain gainful employment or submit 5 job applications per week, a random urinalysis, no drugs without prescription. There should be a $100 restitution payment per month as per this agreement. There is a separate restitution payment schedule on the Walton case, but on this one, she's got to make $100 a month. Have a question? I know. That's what they requested though.
I do. It's right there. We're in front.
No objections to the score sheet, which is 45.6 points. This is a negotiated downward departure. And Judge, because she had the Walton County supervision first, Crestview came out and did a courtesy meet and greet with her. And instead of going to the Crestview office upon her release, she needs to go to Fort Walton Beach for all of her cases. Is that correct, probation?
Yes.
They're going to give you the address of where you need to go. That's not going to be Crestview. The only thing I have not announced is, given the amount of restitution in moving pieces, I would ask the court to waive the cost of supervision for Ms. Williams. May I approach?
Granted. And you got the 26 case number? Correct. Okay. Raise your right hand, please. Do you swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, sir.
You put your hand down. You heard what Mr. McKinney said and you signed the written plea form.
Yes, sir.
How old are you?
34.
How much education do you have?
GED.
Are you able to read and understand the plea form?
Yes, sir.
Did you do that before you signed it?
Yes, sir.
And it's what you read in the plea form, what Mr. McKinney just announced to me.
Yes, sir.
Do you understand as to these charges that you're pleading no contest?
Yes, sir.
And that tells me you believe the state can prove your guilt and you're not going to contest that.
Yes, sir.
And you also understand that by making this plea, you're waiving your right to a trial by jury where the state would have to prove your guilt.
Yes, sir.
In this case, the sentence will be 3 years of probation, concurrent with your Walton County case. The special conditions will include you can't go back to those places, and you must take the class that was announced, and you'll have the restitution that was announced. Do you understand that?
Yes, sir.
You must also maintain employment or submit applications for employment, and no substances without a prescription.
Yes, sir.
And you must pay your restitution at least $100 per month. And when would the first payment be made?
Judge, can we ask for April?
Has Mr. McKinney answered all your questions about the plea and how it affects you?
Yes, sir.
And you're satisfied with what he's done for you?
Yes, sir.
Court will find the plea to be freely and voluntarily entered into and will accept the plea.
Judge, will the court consider waiving the cost of supervision?
I'll waive the cost of supervision until the restitution is paid.
Thank you, Judge.
Next will be Jessica Rainey.
Judge, this is Mrs. Jessica, last name Rainey, 26 CF 234. We are set for a bond hearing this morning. If I may just have a brief moment.
You may.
With Mr. Snell, we keep the white.
I like how you did the tag team there.
Yeah. Jimmy John or something with that too. Shrub. I'm sorry, Judge. Sat right back down. I apologize.
That's okay, sir.
Judge, Ms. Lindsay Rosen in 25 CF 1456. She also has an additional misdemeanor case.
She does.
That's a 26 MM 217. If you recall, she was out of...
217?
Yes, Judge.
Okay.
26 MM 217.
And what's that charge? Do you know?
It's the paraphernalia charge, yes.
POP? Okay.
And if you recall, she was out of custody last time we were here. We were trying to get her evaluated for Keaton. She had a failure to appear on that MM case. That's why she's in custody today. So I'm asking to put this on that 312 without subpoenas. We are still in the process of getting evaluated for Keaton. And surprisingly, recently, Keaton's been getting real quick back to us. So if I hear back from Keaton before 312, I can bring you in this courtroom. I just explained that I'm trying to get all options possible on the table for inpatient rehab.
All right.
So if we can get the 312 without subpoenas.
No objection.
All right, no subs, the denial.
Thank you, Judge.
Mark Robinson is next.
When I am, I will. I'm up there, but I'm.
I don't know what I'm.
Okay. You just call that?
Right.
No.
Judge, this is Mr. Mark Robinson. I have 3 cases on the docket. 23 CF 2606, 23 CF 2731, and 24 CF 2395, all violations of probation. Thank you, Your Honor. Currently, the offer is guidelines, Judge, and this is a 29.625 months DOC. That's what the score sheet reflects. I have been speaking with Mr. Snell about some potential counters. My client was in the Phoenix program for about 10 months. So I'm asking to set this for 3/12 without subpoenas so me and Mr. Snell can discuss the counter offers we've been discussing.
So denial, 312, no subs.
Correct, Judge.
Mr. Snell.
No objection.
All right, no subs on 312.
Okay.
Thank you.
That's for me.
Zachary Rogers is next.
You're welcome. Yep. I put it on 312 outside. Judge, this is Mr. Zachary Rogers. I have him on 26 CF2, 26 CF5, 26 CF6. And if I may announce 2 additional misdemeanor cases.
Granted.
Judge, it is 26 MM2 and 26 MM3. If I just may have a brief moment for his signature. Just following along with me. Your Honor, this will be a change of plea this morning. Plea of no contest. It's a little lengthy, but I'm going to announce the terms. In 26 CF2, that's counts 1 and 2. This is a 5-year standard probation. There's $40 per month cost supervision, $515 in court cost, $100 in defense cost, $50 for the PD application fee. We have 50 hours of community service. No drugs without a valid prescription, no consumption of alcohol, random breath tests, random UAs. Maintain gainful employment, or submit 5 job applications per week. We have the substance abuse evaluation and any recommended treatment. Reserve and order restitution for 24 months. Under this case number, we're also going to reserve and order restitution in the 26 MM2 case for 24 months. Moving on to count 3 of 26 CF2, adjudication of guilt and credit for time served. 26 CF5, counts 1 and counts 2, 5 years standard probation, $40 per month, cost supervision, $615 in court costs, $100 defense costs, no drugs, no alcohol, random breath tests, random UAs, maintain gainful employment, or submit 5 applications per week. Reserve and order restitution for 24 months. And then count 3 and 26 CF5, that's going to be adjudication of guilt and credit for time served. Moving to case number 26 CF6, counts 1, count 2, and count 3. 5-year standard probation, $40 per month cost supervision, $515 court costs, $100 defense costs, no drugs, no alcohol, random breath, random UAs, maintain gainful employment or submit 5 job applications per week. Reserve and order restitution for 24 months. And then the 26 CF 6, count 4 is adjudicated guilty, credit time served. The misdemeanor case is 26 MM2, adjudication of guilt, credit for time served, 270 court costs, 100 defense costs. 26 MM3, that's adjudication of guilt, credit for time served, 270 in court costs, 100 defense costs. All counts and cases to run concurrent. If I may approach with the signed plea form, it's court chief.
If I may add one thing. When there's going to be multiple places that are going to be owed restitution, and when we either submit a stipulated order as to the amount to each place, or if we have to have a hearing on the matter, the goal would be for the court to establish the amount of restitution owed and a monthly payment at that time to pay towards it during the remaining term of the probation.
Okay, I'm not sure I understand what you're specifically asking for.
Once the total amount of restitution is determined and ordered by the court, we'd like an established minimum monthly payment to be included to make sure progress is made throughout the 5 years to pay that.
But you said, so as to each individual restitution amount, you're saying, or as a bulk?
As a bulk. I guess, however it would be the easiest for probation to apply. I don't know how.
Well, and I'm not sure if the rules are the same as they used to be, but if there are three
locations,
three restitution amounts, and the court specifies one payment per month, then when that payment comes in, probation is going to equally distribute those. So I just couldn't make it easy because, you know, we all went to law school because we couldn't do math. It's 300, there's three, they're going to apply 100 to each one of them.
Okay.
And if that results in one of them being finished and then there's 300, they're going to do 150 to each of them. And if the second one's finished and there's one left, then the 300 go. That's the way they'll do it. Now, if we specify that it is, you know, $100 to each of them, then as they're paid off, his obligation for payment would be different. That's the reason I'm asking the question, not trying to turn it into a word problem, but at the same time, I want to be sure that we don't give probation a situation where they're not certain what they need to do and set up a violation. So that's the reason I'm kind of asking the question.
It would be a payment towards the whole sum.
And then it would be up to probation to do their ordinary division among.
Correct.
And they don't do it in the way back. They used to do the math. So if there were 5 people and they would do a proportional. So if, you know, if the total amount, then they would do a proportional. They don't do that anymore. They do it based upon the number of people and they split it equally because it just produced problems for them doing the math. I'm right about that, right? You don't do the proportional unless I order it, right?
That is correct.
Okay, all right.
Okay. That's all I wanted to add.
Okay, no problem.
Judge Mann, just a brief moment?
Yeah, absolutely.
If I may approach with signed plea form?
Granted.
No objection from the school.
All right. Okay, so we're reserving our restitution for 24 months on the misdemeanor?
That's what the state requested, Judge.
And so the restitution on the misdemeanor would be paid in the criminal probation case?
On the felony probation for the 5 years of probation, yes, Your Honor.
Okay. So we're making the payment of that restitution a condition of his felony probation?
Correct. If there is a restitution, yeah, absolutely.
All right, and so probation's not supervising the misdemeanor, the payment of that restitution is a condition of the felony probation?
That is correct.
Okay. All right.
That is the agreement, Judge.
All right. All right, raise your right hand. You swear or affirm to testify truthfully in this matter under penalties of perjury?
Yes, I do.
Okay, and you put your hand down. You heard what Mr. Koch said, you signed the written plea form?
Yes, sir.
All right. How old are you?
27.
And how much education do you have?
High school.
All right, you able to read and understand the plea form?
Yes, I am.
Did you do that before you signed it?
Yes, I did.
And is what you read in the plea form what Mr. Koch just announced to me?
Yes, I did.
All right. And in this case, you understand that you're pleading no contest to all these charges?
Yes.
And that tells me you believe the state has the evidence necessary to convict you of these charges, and you're not going to contest that?
Yes, correct.
Do you understand by doing this, you're waiving your right to a trial by jury where the state would have to prove your guilt?
Yes.
In this case, you will be adjudicated is it with an adjudication?
That's correct.
Adjudication of guilt, and you'll be on 5 years of probation with the fees and costs that were announced. Community service, no substances without a prescription, and testing to prove that. You've got to get a job or keep trying to get a job. Do the evaluation and recommended treatment. The state will have 24 months to determine what the restitution should be, and you'll pay that restitution in the felony case and the related misdemeanor case as part of your obligations in the 5 years of probation. Is that what you understood?
Yes.
Mr. Koch answered all your questions about the plea and how it affects you?
Yes.
And are you satisfied with how he's represented you?
Yes, I am.
The court will find the plea to be freely and voluntarily entered into and accept the plea.
Thank you, Judge.
Is no joke. Just ask him.
That's all I have for the 9 o'clock docket. I don't know if you wanted to do any of the others.
Do we have any others that you show, Madam Clerk?
That was all I had for the morning docket. Mr. Cochran, when did you want to address Jennifer Nolan?
Whenever the court's ready. Your Honor, I have a case that's not on the docket. I just need an appointment on.
All right, so who's that?
Miss Jennifer Nolan. The case number is 25 CF 2458. She has 2 other cases that I'm appointed on, and for some reason it just fell through the cracks for my appointment on this case. She's already had arraignment.
So ordered.
Thank you, Your Honor.
25 CF 2458.
For the record, it's 25 CF 2458.
All right, I did show Peralta, Jorge Peralta.
He pled last week, Your Honor.
He did.
Or last time, whatever. It was with Mr. Koch.
Okay.
You don't have a record of it?
Okay. Showed up on my docket. All right. How about this afternoon? Anything? I think we're 1, 2, 3, 4, 5 PTDs. Any this? Say again?
The one thing, Your Honor, will be a request for opinions. We just got the paperwork on Tuesday. That's going to be.
Ready for trial.
Murray Smith or
If
Smith Murray?
we're interested to learn his name.
Do we know which name it is?
Smithson Murray? It's Smith Murray, yeah, so, but I filed a PTD this morning, the actual motion. There's 3 cases, we just got the paperwork and one was on Tuesday, so we're gonna be asking for, someone that will be here.
Okay. All right.
Are they already here? Is he already up?
Take me just 60 seconds to go get anybody that you want. It's up to you, Judge. Ready to take whatever.
Do you want to go get lunch?
I guess my only concern is we are noticed for 12:30 if someone were to show up, you know.
Yeah.
I'm not so concerned about arraignments, but contested hearings like this where it's possible that a victim or someone else could possibly show. I don't want to.
Yes, Your Honor, we'll adjust to 12:30.
All right. Okay.
Don't want to do any of the one things.
I'm sorry?
Do you want to do any of the one things you just have?
If we got one, I show 1, 2, 3, 4 may be detained for the arraignment docket. Get those out of the way and get on down the road, huh?
I'm sorry, Your Honor.
We have arraignments. I have 4 folks that I'm showing were detained on the arraignment docket right now, clerk. I have Donnell McLean. I have Eric Lucas, Joshua Paulson, and
Do you want those 3?
oh, we took care of Christopher Robinson, right? So that's done. So we just have the 3.
I'll get with him like 3.
You can
Ready? All right, I'll be right back.
Your Honor, may I ask a question about this afternoon? Again, like last time, we're supposed to have a contested evidentiary hearing with Mr. Tony on defendant Bisbee at 2 p.m. I don't see him on the list, jail list.
Mr. Bisbee?
Yes, Your Honor. Daniel Bisbee, I can get the,
Yeah, I have it. I have it right here.
She's talking on that transport list, I believe, is what you're talking about?
yes, yeah. I know he's in jail because last week we had the motion for bond.
I see him on the docket, but I don't, he wasn't transported, right? Okay. What happened, do we know?
Like I said, we'll put it on the trial.
But just for the court's knowledge, Your Honor, it's not going to be a contested hearing. I discussed with Mr. Tony, we should have a resolution.
Okay, so we don't need him.
Well, he may need to plead, and I don't know how the court feels if he appeals via Zoom.
Okay, yeah, ask, since he's going to pick somebody else up, bring Mr. Bisbee with him, please.
Thank you.
Eric Lucas?
One second, sorry. Your Honor, we have Mr. Eric Lucas, case number 26 CF 0175. If I can have one moment.
Yes, sir.
Your Honor, Mr. Lucas, I'm going to ask, we're going to enter a plea of not guilty. I don't, do we have the information? If I may approach the court.
Granted.
To acknowledge receipt of the information, waive formal reading, enter a plea of not guilty, and ask to leave this set for the next court date.
And Your Honor, the current offer on this case is adjudication of guilt, 9 months in the Okaloosa County Jail, $22.96 to Walmart for trespassing at Walmart.
And I've relayed that to him.
All right, and this is set for what date, Madam Clerk?
It looks like it's set for the May 11th pretrial conference cycle.
We'll leave it on May 11th, or advance it on 3/9?
I'd ask for 3/9, Your Honor.
All right, advance it to 3/9.
No. You have the information.
Granted.
Mr. Cocker.
Yes, Your Honor, we have Mr. Donna Lambert, 26 CF 0153. We acknowledge receipt of the information, will waive formal reading, will enter a plea of not guilty, and we'll ask to leave this set for the next court date, which I believe you said May 11, Your Honor.
When's this set for, Madam Clerk?
It is set for the May 11th pretrial conference cycle.
Okay. And if you reach a resolution sooner, we can advance it. Is there a current offer?
Yes, Your Honor, it's adjudication of guilt, 7 years in the Department of Corrections, 7 years of that being a mandatory minimum, and then a $50,000 fine, which is also mandatory, Your Honor. He also needs, so that they're all tracking together, he has a VOP in 25 CF 2033. If we can make sure that tracks with this 26 CF 153.
I have it on my list. All right. So ordered.
Thank you, Your Honor.
See you later. God bless you.
Thomas.
Your Honor, this is Mr. Joshua Paulson, 26 CF, thank you, Deputy, 26 CF 190, Your Honor. And Judge, the current offer is the guidelines, it's 45.68 months DOC. Now it's 45.68 months is the current offer.
Sir,
One second, please. Hold on a second.
Okay.
Judge, today, just put that back in your folder. Hear me out. We're going to enter a not guilty, waive formal reading, request this be kept. I believe this is on the 511 pretrial docket.
That's
Malcolm?
correct.
Thank you. If we keep it on the 511 docket, Your Honor, we'll enter a not guilty today, and we'll speak privately at the jail.
Everything right here got dismissed.
Okay.
I reported up on,
Thank you.
Clear with the Star, the
Please.
statute number got dismissed, everything got dismissed.
I hear you. What's off right
Everything is bogus on there. 35 things wrong on there, that's written wrong, from the Fulton Police Department.
Josh.
And the statement of all of
Thank
this.
you. Not the time or
Should be
place.
in jail for that one.
Certainly. So if we keep this on the 511 docket, Your Honor.
17th District.
Please, you're gonna get in trouble.
Dismiss it.
Josh, what are you doing?
Right now, right? We're in not guilty, we talk privately, and when we're done here, you call it that, yeah, I'll make a scene, right? I don't know.
All right,
Thank you, Judge.
so ordered.
Thank you.
All right, we'll see you at 12:30.
Thank you, Judge.
Thank you, Your Honor.
All rise.